Hi, my name is Zev Eigen. I'm very happy to be here today. I'm the founder of a company called Syndio Solutions, and I'm going to talk to you a little bit about the California Fair Pay Act, what it does, and what you should do as an employer to comply with it, and some tips about compliance as well as challenges associated with complying with the new law. I'll start a little bit by telling you a little bit about my background before we get started. Before founding Syndio, I was a law professor for 6 years at Northwestern and visited at NYU and Yale. I have a PhD from MIT. I've been working as a data scientist and statistician and labor economist as an expert on compensation equity and related areas for 15, 20-ish years. My background before that was I was in-house counsel with 20th Century Fox. I've practiced as a labor and employment lawyer with the law firm Littler Mendelson, and I have also have an undergraduate degree, a Bachelor of Science in Industrial Labor Relations from Cornell School of Industrial Labor Relations. I've been doing compensation equity analytics for a very long time, and as the laws have continued to evolve in this space, I've paid a lot of attention to how they've evolved, and I'm happy to share with you today some of that information about how they've evolved, how they can be interpreted both by the plaintiff's bar and agencies like the DLSE, the Division Labor Standards Enforcement, and the DFEH in California and other jurisdictions. I've looked at compensation and reviewed compensation for hundreds of employers, and I think it's really important that the law is understood and you have an understanding of the law and you understand how the methods and statistics work so that you can correctly identify risk and get ahead of risk before it materializes and becomes extremely costly. So just as an outline for today's CLE, I'm going to go through what the new laws, especially in California, say. We'll focus primarily on California. I'll mention a little bit about federal law and talk a little bit about case law in California that's beginning to develop in this area. Then I'll talk about what employers should do to comply with the law. And lastly, we'll talk about some compliance tips and challenges associated with complying with the new law. So to start, federal law has been on the books for a long time. The Equal Pay Act, 29 U.S.C. 206 D1. And the Federal Equal Pay Act prohibits an employer from paying different compensation to employees of the opposite sex who work in the same establishment and perform equal work in jobs that require equal, and the operative word there is equal, skill, effort, and responsibility, and which are performed under similar working conditions. And employers may justify differences in pay with a seniority system, a merit system, or other things based on any other factor other than sex. And the EPA has been on the books for a long time, but Vicki Lipnick, who's the acting chair of the EEOC, and others have informed me from other agencies that there's been very little case law on the EPA, enforcing the EPA, primarily because of the wording and how it is structured. You have to look at people in the same establishment doing equal work with equal skill, effort, accountability, and you'll see how the states have taken some of that language and transmogrified it to enable employees to bring claims that are, it casts a wider net, makes it easier to bring claims. Secondly, it's important to note that not only is there federal law on the books, there's also the OFCCP, which applies to federal contractors. Effective August 15th, 2016, OFCCP regulations prohibit contractors from paying different compensation to similarly situated employees on the basis of sex. And the factors include task performed, skills, effort, level of responsibility, working conditions, job difficulty, minimum qualifications, and other objective factors. Also effective January 11th, 2016 for federal contractors, OFCCP final rule under Executive Order 13665 prohibits discrimination against those who inquire about, discuss, or disclose their own compensation or compensation of other employees or applicants. And you'll see, similar to the laws that have evolved and are on the books in California, it's very important that employers understand not only that they can't pay people differently for doing the same or substantially similar work, but that they also need to be very mindful of inquiries made by employees or applicants to avoid creating risk there too. Now, many states, not just California, have enacted pay equity laws, and more are developing such laws. It's my understanding that at the time of this filming, every state except for Mississippi and Alabama has some form of compensation equity regulation coming online, or they already have laws that are in effect. And as you see from this slide, California's law, which we'll discuss in detail, went into effect on January 1st of 2016. It was amended January 1st, 2017, and other states have laws that are online or coming online. Massachusetts, for instance, July 1st, 2018, Maryland, October 1st, 2016, New York, January 19, 2016, etc. The California Act, known as the Fair Pay Act, which is embodied in California Labor Code, Section 1197.5, again, went into effect January 1st, 2016. The CAFPA prohibits paying employees of the opposite sex less than those performing substantially similar work, different than the federal law requiring equal pay for equal work. It has since been expanded to cover race and nationality. Where substantially similar work is defined in the Act as a composite of skill, effort, and responsibility. The other thing that's important to note about the California statute is that there is no same establishment clause like there is in the federal law. There is no pay secrecy, and the Act promotes pay transparency. And the other key thing to note about this law is that it may be paired with a Plaintiff's Attorney General Act claim, PAGA claim in California, like the suit filed against Uber recently, which we'll discuss. An employer must meet the new higher standard of demonstrating that any pay differences are tied to a substantial or an absolute business necessity. The employer must also demonstrate that its reliance on any of the factors that it can use in its defense are reasonable, and that one or more of those factors entirely accounts for any wage differential that is problematic from a statistical standpoint. Simply pointing to a factor like tenure or educational attainment as a partial explanation is no longer sufficient. As a result, the burden for employers in defending actions under the California law is significantly greater than the burden under the federal Equal Pay Act. Under this slide, you'll see that there's some variation across states in the protected categories. California covers sex, race, and ethnicity. Note that in other jurisdictions like Oregon, there are numerous other categories that are covered by those other states' acts. Oregon is interesting because it covers sexual orientation in addition to the other ones listed on the slide. Sexual orientation is a challenge to audit because unlike gender or race, it is not something that the employer has or knows without additional inquiry. And one of the questions I raised for Oregon legislators is, how should an employer, a well-meaning employer attempting to self-audit and ensure that they're complying with Oregon law, how can they possibly audit for sexual orientation without going employee to employee and asking, what is your orientation? So I think the point that I want to make is that these laws, including California's, were passed sometimes with an eye towards enforcement, but not necessarily with a sufficient understanding of the complexities required of employers who want to get ahead of the law and ensure that they're complying. So while it might be easy for plaintiffs and plaintiffs' lawyers to bring claims, employers are challenged to ensure that they're doing the right thing and ensuring that they're complying. And there are some complexities there that we'll discuss that are more specific to California, but I bring up the point about Oregon's law to illustrate the point. Now, the other thing that's important to note about California's law is that the amendment established the same establishment provision. So you can look across locations within California for comparisons, but you're not obligated to look only, or not enabled to look only within one establishment when you're finding people who are doing substantially similar work. So for instance, if you're in California and you have locations in Fresno, Sacramento, San Francisco, San Diego, Los Angeles, and they're all salespeople doing substantially similar work based on skill, effort, and accountability, you would put them all into one substantially similar group for purposes of comparing them, and you'd be allowed to differentiate pay based on market. So if you're paying people more in San Francisco versus Fresno, or Los Angeles versus somewhere else, you're allowed to do that. The law accounts for that as a way to do it, but you wouldn't be looking just within one location, say San Francisco, as a point of reference, independently of all the other ones, all the other locations. So both California and Massachusetts, when you're looking at the question of who is in the comparison group, say that it's got to be folks doing substantially similar work when viewed as a composite of skill, effort, and responsibility, and performed under similar working conditions. How you figure out what an SSG is, or substantially similar group of employees, is a difficult one, and we'll talk later about how you can comply as an employer, but I would urge employers to pay a lot of attention to that exercise of identifying who is or is not within a substantially similar group. And when you're looking at complying, make sure that you're doing this in a way that looks at risk both narrowly and broadly. Meaning, if you have, let's say, engineers, levels 1, 2, and 3, perhaps each one could be analyzed as a separate substantially similar group, but it makes sense to combine them into composite SSGs as well. Perhaps engineer 1 and 2 combined, or 1, 2, and 3 combined, or 2 and 3 combined. The defenses available under the California Fair Pay Act are those listed on the slide and in the Act. Seniority, merit, systems that measure quantity or quality of production, or bona fide factors other than sex may be used to account for the entirety of any problematic gap that's observed between men and women within a substantially similar group, or SSG. Bona fide factors other than sex, like educational attainment, training, or experience, those require employers to show factors that are non-discriminatory, job-related, and consistent with business necessity. Employees may prevail, as I mentioned earlier, by showing a less restrictive alternative, and prior salary may not by itself justify any pay disparity. So there's a lot of important points to make in these defenses that are enumerated here. First, it's really important that if an employer says they want to use something like educational attainment to account for differences within an SSG, the employer has to actually care about educational attainment for this SSG. In other words, it has to really matter, and it has to be related to the jobs being done. So in most employment, there are instances in which educational attainment matters for some SSGs, but not necessarily for all. If you have people doing science or technical matter or research, sure, you might pay people differently if they have a PhD in molecular biology versus not. But if you don't also pay your janitorial staff more for having a PhD in molecular biology versus not, which is probably the case, you cannot apply that educational attainment explanatory feature in the same way as you did to the research and development group or technicians as you did to, let's say, your janitorial staff. It's also important to note that to point out California's Assembly Bill, or AB Section 168. AB 168 says that an employer shall not rely on the salary history information of an applicant or for employment as a factor in determining whether to offer employment to that applicant or what salary to offer an applicant. Upon reasonable request, the employer has to provide the pay scale for a position to an applicant applying for employment. This section applies to all employers, including state and local government employers. And nothing in Section AB 168 shall prohibit an applicant from voluntarily and without prompting disclosing salary history information to a prospective employer. If an applicant does that without prompting, nothing in that section, nothing in AB 168, shall prohibit the employer from considering or relying on that voluntarily disclosed salary history information in determining the salary for that applicant. And consistent with the California Fair Pay Act, nothing in Section AB 168 shall be construed to allow prior salary by itself to justify any disparity in compensation. So that's a lot put all together. I would strongly urge employers not to ask employees about salary history or even salary expectations, which is lawful under AB 168, but it can create problems. And we'll talk a little bit more about this later, about why it may not even be advisable to touch this. And even voluntarily disclosed information, if you use it and then rely upon it, if it creates liability down the road in that substantially similar group, nothing would eliminate that risk if you still have that risk. So take note that anything you do on the front end, whether it's lawful or unlawful under AB 168, if it creates risks down the road, it may be that your policies on hiring just kick the liability can down the road and create liability that you later have to deal with. Note that pay transparency is a really big component of this law. Employers are prohibited from enjoining employees from disclosing, discussing, or inquiring about their own or co-workers' wages. And traditional labor specialists who know about the National Labor Relations Act and federal law will say, well, federal law has made that's been the case under federal law for a very long time, because under the National Labor Relations Act, you are already not allowed to stop employees from talking about their compensation with their fellow employees or for the purpose of trying to organize and enjoy and participate in concerted activity. The other point to make here is not only that it's important to pay attention to this, but not to ignore instances in which employees come forth and ask about this. There's no obligation, nor should employers disclose other employees' confidential information, but it's very important that you pay attention to these requests, and certainly that that employers don't retaliate against employees for asking or inquiring about their pay relative to their peers. Now, even though these laws are relatively new, we have seen some case law that has emerged, and anyone who's picked up a newspaper recently will tell you that both sexual harassment, sexual discrimination, and compensation equity, making sure that men and women are paid the same for substantially similar work, is a very hot topic in the news today. And there is a very clear ramping up of litigation in this space. We've seen some cases already filed, as noted in the slide, and it's very clear from the plaintiff's bar and talking to folks who are experts on that side that we're going to see more compensation equity litigation in the coming years as the statute of limitations extends. So here are some cases to note. The first one is Amandano versus Uber Technologies. This is a race and gender claim filed under the California Fair Pay Act, and it attaches, as I mentioned, the Plaintiff's Attorney General Act, the PAGA provision, which enables the putative class here to extend the liability on a per violation basis. So this is a allegedly very large scale and potentially very costly claim or set of claims that have been filed by female engineers working at Uber, alleging, among other things, that they were paid differently based on their wages and their bonuses than similarly situated or people performing substantially similar work in their engineering group. That was filed in October of 2017 in San Francisco. The next case on this list, Jowett v. Oracle, was filed in San Mateo State Court in August. This is a class action alleging that female engineers and developers were paid in violation of CAPA. They were underpaid relative to their male counterparts in the engineering and developers. And you can probably sense that there's a trend. These are both technology companies that have grown very rapidly, in Uber's case especially, and there are female engineers and female developers in the technical field that are alleging that they are not paid the same as their male counterparts. You may have also read or seen about Google and its run-in with the law as well. And again, is a very clear thread that women in technology are taking note that they might be paid less for doing substantially similar work as their male colleagues and male counterparts. And there is going to be more case law, I predict, in this space as time goes on. The other two cases noted here, one is against, actually they're both law firms, and I mention these because folks who are at law firms, I've reviewed compensation for law firms, even law firms that say that they are paying people with limited subjectivity or in a stepwise fashion for associates and shareholders. I think it's very important for law firms themselves to carefully review their compensation, including all forms of compensation, not just the stepwise part, but any other fringe or discretionary compensation that's given to partners and associates, as well as staff at law firms. There have been several cases filed against law firms. Two are noted on the slide. One is against Steptoe and Johnson, and this is a federal case filed in June of 2017. This is a former junior associate who was hired as a contract attorney. She was with the firm for less than 3 years, and she alleged that she was making almost half of what other allegedly substantially similar associates were getting paid, and she was receiving strong evaluations and strong reviews. She says that she alleges that she complained numerous times about unequal pay and nothing was done. And whether that allegation is true or not, putting that aside, again, it's really important if you are receiving complaints or comments or thoughts from employees that you take those things seriously. That should be a triggering event that should make you think, okay, we really need to review the compensation for this organization, even before you respond to that employee. It's very important because you may respond and not fully understand and not fully have done a statistical review of all the people who are substantially similar to that employee. If you don't do that, it's very hard to accurately respond to one-off complaints. Just eyeballing the numbers is usually not good enough. It could be, but it's not good enough in most cases. The last case here, Jane Doe v. Proskauer Rose, filed in DC. This is the only non-California case I mentioned, but it's another law firm, and it's a recent one in May of 2017. This Jane Doe, who is not named, it's redacted in the case, was 6th among her equity partners for billable hours, 18th among equity partners for origination, yet 32nd among equity partners for compensation, and it was an order of magnitude difference in the allegations. So again, law firms, even ones that say that they are paying attention to or they're paying associates and shareholders according to a formula or objective criteria or standards, it's still very important to review compensation and ensure that it's done in a way that's mathematically correct and under privilege, etc. And we'll talk a little bit more, we'll talk right now about what employers should do to ensure that they're complying with these laws. So as you see from this slide, I think there are a lot of really important tips that employers should heed in order to make sure that they're ahead of these laws and not creating risk as they go forward. And there are a lot of reasons why employers should review their compensation now as opposed to waiting until perhaps they have a claim like the ones we described. First, it's important to get ahead of representative actions or class actions. Second, in some jurisdictions like Massachusetts, there's an explicit self-audit defense available. Now, there's no explicit self-audit defense available in California, but I would argue that one could say it's implicit in the sense that if one has taken reasonable efforts to review and correct compensation, it has the effect of showing or making it less likely that an employee will successfully bring a claim. And it increases the odds that an employer will be seen favorably because it is trying its best, it's taking reasonable efforts to reduce any compensation equity disparities that it has observed. And for sure, we have seen that as employers do their best to try to account for gaps and fix gaps, it makes it significantly less likely that those employers will be subject to the same attachment by plaintiffs' lawyers as we might see for ones who are not paying attention and not correcting any problems they see. Additionally, it's important to there is precedent in other jurisdictions for agencies requesting employers or mandating, in some instances, turning over of payment data. In Minneapolis, for instance, and in some instances in California, agencies like the DLSE or DFEH may request that you turn over data, that an employer turn over data. If you review those data beforehand, it's much less of a fire drill when those requests, if those requests come in. Additionally, as mentioned, pay transparency is required. It's really important. And you have to know what to say when an employee asks about compensation. Without having done the review ahead of time, it's almost impossible to do that in a way that makes sense. This is related to complying with AB 168 and avoiding creating pay inequities. If you don't understand where your SSGs are and where the math says you have to be in terms of ranges, it's very difficult to comply with AB 168, and you may be creating liability and exacerbating problems. Lastly, it's very useful to be prepared for internal complaints. Responding to one-off comparisons is very difficult without comprehensive review, as noted. And then aside from the legal risk and the reduction of legal risk that we've been describing, there's an HR benefit and a PR benefit. The HR benefit is clear. If you pay people correctly, you are less likely to have turnover, you're more likely to have happy, productive employees, and certainly there's a PR benefit of avoiding the catastrophic publicity that can echo for a protracted time for companies that are in the public and may suffer the bad PR of a claim being filed against them or a class action being filed against that company alleging pay inequity. Okay, so now we have a clear sense of what the California state law is, requiring employers of any size with any number of employees, whether they're exempt or non-exempt for Fair Labor Standards Act purposes, to be paid the same for substantially similar work and based on skill, effort, and accountability in working conditions, and what the defenses are, that they can, you can use bona fide non-sex-based things like educational attainment or other factors like that to account fully for any gaps. We've also learned that there's variation in the in the federal law, the EPA, and also the OFCCP that applies to federal contractors working in California. And we also learned that AB 168 applies to all California employers, that requires employers to not take into account the prior pay history or prior salary or prior compensation in setting and determining pay when they're hiring new people. The obvious point here to make, and when you look at the legislative history for the California Fair Pay Act and AB 168, is that the California legislative body noticed that, as is the case in every state in the union, there is a gap in the market between what men and women are paid. And additionally, now that it extends to race and nationality as well, in addition to sex. But originally, the impetus behind the law was this observation that there is a gap in pay between men and women. And the law is designed to shift the burden, if you will, to employers to rectify that situation. So they can't rely on market factors because that's just inheriting the risk and putting it down the road. That's really the purpose behind AB 168 and these other bona fide factors other than sex being enabled to account for the difference. It really is a difficult thing for employers to shoulder that burden of redirecting or resetting the labor market for the work that they're doing. But that is the point of the law, and as one director of the Department of Fair Employment and Housing said on a panel with me, it's supposed to be hard. It's supposed to be challenging for employers. It's not supposed to be easy. So we have seen many employers attempting to comply with these laws and having to fundamentally reassess how they handle hiring, how they handle recruiting, how they evaluate people in setting and determining comp once they're hired. And that has been a lot of work for employers. I would argue that it's important for employers, as mentioned just a moment ago, to do these things for the HR reasons, the PR reasons, the risk avoidance reasons, and all the other reasons we just mentioned. But it's not necessarily an easy road to go. Next, what we're going to talk about is how to review comp and what are some of the notes and challenges associated with complying with these new laws in California. And as I mentioned at the beginning, I've been doing this a lot for employers, and I've noticed a lot of variation in the market for how employers go about trying to comply with these laws. Some are intent on doing it themselves, some work with consultants, some work with law firms, and there really is a lot of variation in the approaches I've seen. Some are great, some are dead wrong, some are in the middle. So I really urge caution and leveling to make sure that anyone who's trying to comply with this law or understand this law do it in a way that is with the guidance and help of experts. I'm going to give you some overview and some understanding of the methods and process required to review the comp for employers, but it really is not a complete set of analyses. We're not going to get into the weeds in the math entirely and answer all the questions for every case. So it's really important to understand that there's variation and subtlety that has to be taken care of correctly. And there are definitely methods of doing that, but please do that with the help of the right processes and experts. The basic review process that I use and Syndio uses and others use that I think is done correctly on the plaintiff side and agencies follow as well are these two steps here. And it really is tied directly to the law itself and how it's written and intended to police the workplace. The first question is, for any SSG, let's pretend we're just looking at one substantially similar group or SSG. The first question is the observed gap between men and women statistically significant using accepted statistical indicia and criteria and standards? Now, I want to pause on this first question before we get to the second one to make a point. What does it mean for people to be paid the same for substantially similar work? Now, it cannot mean paying everyone in that SSG the same to the penny. If it did, forget about reviewing. I have much easier advice. Just pay all your salespeople, all your lawyers, all your associates, everyone to the penny the same. That would be a very unusual and uncharacteristic and frankly inconsistent interpretation of this law. When I say inconsistent, I mean inconsistent with how agencies are saying it should be interpreted and enforced, legislators, etc. So what is it if it's not paying people to the penny the same? Well, it has to be looking at the distributions of men and women within the SSG, the substantially similar group, and looking to see whether those distributions are different from a statistical standpoint. So what that means is, if you have a situation where there is a gap, let's say it's an hourly rate and men are paid $18 an hour and women are paid $16 an hour, there's a $2 gap there. The question is that gap occurring by non-random chance, or is it likely to be occurring by non-random chance from a statistical standpoint, such that that would give rise for an employer to have to explain that gap? Because an employer would not have to explain random noise that would be the reason for an observed gap. And statistics test those distributions, and there are standard tests like t-tests or z-tests, which can be applied to test or other tests as well that are non-parametric for smaller groups. But in general, we can use standard tests to see whether those gaps are occurring by random versus non-random chance. And that really is the important first step. Another example to illustrate this point. I know lawyers sometimes tell me, oh, I hate math, Zev, don't tell me math. But one point very quickly to illustrate this point is coin flips. If you flip a coin 100 times, we would expect, probabilistically, for the outcome to be 50 heads. If it's a fair coin, it should be heads, tails. Should come up 50 times heads if we flip a coin 100 times. Okay, that's the expected value. Let's say we ran the experiment here and we did actually flip the coin 100 times, and let's say it came up heads 48 times. Well, there's a gap between actual of 48 and expected of 50. There's a 2-point gap, a 2-number gap. Well, do we think that gap could have occurred by what's the likelihood of that gap occurring by non-random chance? Well, statistically, even just intuitively, you might think, I'm okay, we'll tolerate, it's probably just random that we're 2 off of 50 from the actual versus expected. Now, what if we did the experiment and we flipped the coin 100 times and it came up heads 80 times, right? Now the gap between actual and expected, 80 minus 50 is 30. Now we might say, wait a minute, now that gap, I have a problem with that because it's probably very unlikely to get that result. It's possible that it could be randomly you get that 30-point difference between actual and expected, but it's pretty unlikely. And that's exactly where statistics is absolutely necessary to differentiate between that 30-point gap in the latter example and the 2-point gap in the first example. There are standard cutoffs and standard criteria. You can't eyeball gaps. Sometimes you have gaps that are very small in magnitude, but are definitely a problem under the law. Other times you have gaps that are big, but not a problem under the law because of distributions, meaning sometimes where you have a big gap, sometimes men are paid more than women, and sometimes women are paid more than men. That might even out. So you might have outliers on either end of the extreme. Men paid a lot, women paid a lot. Men paid a little, women paid a little. So just because on average there's a big gap doesn't necessarily mean that you have a problem under this first inquiry. Same thing, and as an example, for a small magnitude gap that is a problem under this law, let's say you had 100 people, 50 men, 50 women in an SSG, and every man was paid $18 an hour, and every woman was paid $17.99 per hour. Well, I don't have to run the math to tell you, even though that gap is a penny, there's no variation, it's just a penny and there's no variation, that would be a violation of the act, even though the magnitude of the gap is very small. You get my point. This is a mathematical series of tests that are applied here. It can't be eyeballed. And to answer this first question, it's really important that it's done correctly. Otherwise, you can be chasing something that either is or is not a problem, and you might be exacerbating a problem or creating one that didn't exist in the first place, addressing risk that wasn't a risk. So it's got to be done right. Now, if it's done right and there is a problem, in other words, from a statistical standpoint, that gap that's observed is unlikely due to random noise or chance, then the law permits employers to try to explain fully and account for fully that problematic gap, that observed problematic gap, with legitimate measures noted in the statute, such as educational attainment, tenure, or non-gender-based measures of performance. Couple things on that. Again, these are standard mathematical tests that need to be applied to see what effect these other non-gender things have on comp. How much of the variation in comp and the gap is explained by the inclusion of these things in a mathematical model. Sometimes it's called multivariate regression, sometimes it's called ordinary least squares regression. Sometimes there are other tests that are applied, but there are statistics and standard math that need to be applied to test whether these other things, these other legitimate factors, account fully for the observed gap. So for instance, tenure, let's say, which is a pretty reasonable one to hypothesize accounts for gaps. The longer you're with the company, the more you get paid. And let's say hypothetically, there are men who have been at the company longer than women, so that would account for the gap. You can't eyeball that. You have to put it into the model and run the model correctly and observe whether the gender coefficient, the gap between men and women, remains statistically significant net of the included controls. And again, this is a mathematical test. It's not something that you can just do without an understanding of how it's done. It's got to be done correctly. And that is really, I think, the best way to assess whether you're in compliance with the law by SSG. Now, on this next slide, you'll see I list 4 categories of data required. And in reviewing compensation, it's really important that you get the data right, or as right as possible, because otherwise you have a garbage in, garbage out problem. I've seen employers say, oh, you know what, Zev, I'm just going to review it based on existing job titles. That might be okay for some employers. In fact, for some very shallow organizations, job titles might be perfect. But for other organizations, job titles might be too narrow, and there might be multiple job titles that need to be included in one substantially similar group. So it's really important in this first category of data to identify the grouping, the SSGs, correctly, and to ensure that you're not relying on convenience, but that you're taking time and looking at job titles and job descriptions to ensure that you're identifying groups in a way that makes the most sense for your organization. I always say, imagine you're going to be on the stand and you're going to have to testify about why this constellation of job titles should or should not be included or excluded based on what they're doing, their skill, effort, accountability, and again, their job titles and job descriptions that you have on file are going to be exhibits in that hearing or matter. So pay very close attention to ensure that there's harmony between what employees are doing in reality and what they're doing on paper. Sometimes that's a problem that we observe as part of the review process, where someone will say, oh, we gave Joe managerial discretion and we're paying him more for that. On paper, that's not the case because he's still listed as something else. Okay, well, harmonize reality and what's on paper to ensure that Joe, if you're going to argue he shouldn't be in that SSG, you can explain why, and it's harmonious with what Joe's job description and job title are. The second category of data are gender and race. Obviously, you need that information to differentiate and measure. The third is another one that's a little tricky. It's what are you going to measure for compensation? Now, the statute says wages, but it's highly unlikely that a California court will allow an employer to circumnavigate the obligations of the Fair Pay Act by simply labeling compensation something other than wages. If that were the case, a fix could be, well, instead of calling it wages, I'm just going to call this bonus. I doubt that that would be a viable defense. So what we or I tend to suggest is looking at total annualized compensation, including things like equitable grants, fringe benefits, bonuses that are discretionary, and anything that's not lockstep, and anything that has some element of discretion on top of the base pay. And that varies by employers. And again, it's really important to note, and of course, you have to annualize it, so it's an apples to apples comparison. But it's really important to exclude things that are non-discretionary and include things that are discretionary. And where that gets complicated sometimes is with equity grants and with people on commission or other kind of varied sales plans or other ways of non-traditional compensation. Lastly, the last category of data are you have to think about what are going to be the explanatory features that are going to be used to account for any gaps that are potentially problematic. And again, it could be things like location, hire date, which is how you make the variable tenure, and performance evaluation scores. And again, it's really important that those things be job related and that they be tested to ensure that there's no problem or bias in those measures themselves or adverse impact of those measures themselves. If your performance evaluation scores are always given 5s out of 5s to men and women tend to get lower scores, performance evaluation may not be a good objective measure on which to rely in accounting for gaps for reasons we discussed. Okay, now another thing I want to focus on a lot is what is a substantially similar group? Again, it's really hard to do this for some larger organizations, or there is a lot of complexity and variation in what employees are doing across the organization. Sometimes what's been very helpful for some organizations who are challenged by that is looking at a grid of function and role, where functions are the larger organizational segments, such as legal, operations, or IT, and the roles are the titles based on skill, effort, and accountability. You can make a 2x2 grid like that and then start populating that grid. Then what you want to start thinking about are what are the rows or combinations of rows, or what are the columns or pieces of columns, pieces of rows or pieces of columns that should be lumped together. So for instance, let's say you had a VP and there are a VP, role of VP, and there's a VP of engineering, there are VPs of sales, VPs of marketing. Maybe you want to isolate each one of those and evaluate them separately as an SSG, and then combine them into one composite of all the VPs. Next, it's important to understand how you can look at explaining problematic gaps with these controls, with these explanatory features. And again, they have to be related to the job. It's really important that you use controls that are related to the job. Invariably, what comes up is an employer who's run something with a consultant and they've applied all the controls uniformly to every SSG or in one big model. Both of those can be problematic ways of analyzing the compensation equity because controls may not apply to everyone, as mentioned earlier. For instance, educational attainment, an example I gave earlier. Next, it's really important, this is an important step in reviewing compensation, of evaluating the non-economic solutions that may be presentable. And that's an important feature. Like, you have to look to make sure that job titles and job classifications are done correctly, that people are in the right SSGs, and that there might be additional controls that you need to quantify in order to ensure that you're measuring differences correctly and more objectively. That's maybe the silver lining of this review process, is you end up with a system that tends to be less prone to bias, less susceptible to manipulation or subjectivity, and less likely to create risk down the road. And this is really what I like to call asking the why questions, to avoid having to fix and refix the same problems over and over. So ask things like you see on the slide here. How does your company currently set initial and ongoing compensation? What are the factors taken into account, and how does that process happen? Are there things like performance evaluations or other things that can be reassessed to make sure that they're done in a way that most closely harmonizes with how the company should be rewarding and encouraging people and incentivizing people to do their best at their job? How much discretion is delegated to decision makers in this process? If there is a lot of discretion delegated, are there guidelines or training for decision makers on how to exercise that discretion? You might want to think about that as part of this process. How are employees grouped or compared for pay purposes? And what is the rationale for these groupings? If there isn't a lot of thought given to this already, this is a great time as part of this review process to shore those processes up, ensure that there's a more direct connection between how employees are incentivized and paid and how you want to do those things. So if there's a more objective method or things that are important, you can memorialize those things in a way that reduces risk on an ongoing basis. So one example of something that comes up a lot is in diagnosing those problems. I'll give you two examples. One is educational attainment, and then the other is tenure. So in this slide, you see we graphed out by educational attainment in this SSG, high school, college, master's, and PhD, little quantile plots for men and women. And what you'll note here is that women tend to be under-rewarded relative to men. Those are the purple bars relative to the blue bars, for having masters or PhDs. And you can even see in the PhD bars, the male, the lowest paid man is still more than the highest paid woman who has a PhD in this substantially similar group. So this helps diagnose the why question. So where you have problems, in this SSG there was a problem, it was helpful for the employer to understand that they were rewarding people more for having educational attainment, but men were rewarded more so than women. And that was a problem because there was too much discretion and not enough guidelines given to managers in exercising that discretion. The second example I have here is a graph showing compensation versus tenure for actually the same SSG identified in the prior slide. And here you note something very interesting in these two lines. One showing the trend of men and their relationship between comp and time, how long they're with their company, and the same thing for women. And what you'll note from these two trend lines on this graph is it's actually not an issue in this case of women getting paid less than men to start. In fact, if you look at the graph, women tend to be paid more than men when they start in this substantially similar group, or SSG. However, look at the rate or the slope of the two lines, and you'll see that men are rewarded more and faster than women for being at the company. And women, their line is flat, meaning that they are relatively flat, meaning that over time, women are not rewarded as fast as men in this SSG for their longevity. And that might be for other reasons that are explainable. But again, the point here in reviewing compensation is to try to understand where there is discretion and answer the why question. So if there is a problem with how discretion is afforded here for this SSG or why people are getting what they're getting over time, this is strong evidence that an employer should think about reevaluating those processes. Okay, so some more comp review tips. First, it's really important to ensure that the analysis is protected by attorney-client privilege. It's not a great idea to just have someone in the comp department review things and perhaps create smoking gun problems in reports. Remember, the data themselves are never protected by attorney-client privilege, but analyses can be if they're done correctly under attorney-client privilege or as part of attorney-client work product. Second, this is a really important one. You got to do the analysis right. It's not a good idea to try to do it with your cousin who is an accountant who thinks he might have read something about statistics. The same way it's sometimes a problem with our clients or other folks who say, oh, I don't need a lawyer. I read a book once about this law. I can handle it. Yes, in some instances that's the case, but it's often not the same. An example my friend likes to give is ice cream. So yeah, you can make ice cream at home by whipping the eggs and doing it yourself, but it never tastes like Ben & Jerry's. And that's sort of like this too. You can do the math, you can figure it out, you can muddle through, but invariably when I've done this for clients, on behalf of clients, even with small clients, complexity invariably is part and parcel of the process, and you got to make sure it's done right. And there are systems that enable you to do it. Avoid the following mistakes and traps. This is one that I see, it comes up fairly frequently. It's not the case that your HRIS system or comp system is automatically doing what you need to do to comply with these laws. It just doesn't happen. It can't possibly happen. The most easiest thing to point to showing that that's wrong is our substantially similar groups. It takes work to get the SSGs set up. It takes work to identify the controls. It can't be on autopilot generated from your HRIS system, which might just be looking at simple tests within bands or within levels or sometimes grades or job titles. Again, this is a problem of over-identifying or under-identifying risk because it's not done correctly. Again, don't think that Joe in accounting can handle this. If he's not an expert on the law, the data and math and methods required. That's another thing that I see a lot. Another thing I see happening is, and don't do this one either, thinking that it's better not to look than to look. I've had employers and even some lawyers on the defense side say, you know what, it's best not to look. If you get sued, then you'll deal with it then. If you look at some of the numbers claimed in the class action matters and the PR value or the problems associated with PR and HR for comp equity, it makes no sense when you can analyze this correctly for a price point well below what it's going to cost you to get it wrong and to end up in that hot water. It makes no sense, especially when some of the HR problem or disutility associated with paying people inequitably, as an employer, you may not even notice. A lot of times people see turnover as something disconnected from comp equity because they can't identify that as a problem. It could be the case that some percentage of your turnover is due to the perceived pay inequity, and it's really important to get ahead of that risk. Lastly, avoid the situation where you go to review comp. This is sort of the flip side of the last point of going to review comp without a willingness, a plan, or even a budget to correct issues identified. And again, it's important to have the understanding that there are non-economic fixes available that we can help identify as part of that process, and you should consider non-economic fixes. But after those are exhausted, there is often the need for economic remedies to correct, and math will help you figure those out. It does not make sense to review comp if there is no willingness, plan, or desire, if you will, for a company to try to make those changes. Even if they happen over time, which sometimes has to happen for budgeting purposes or some other purpose, it's really important that that be done with an eye towards the needed corrections. Okay, so we've got a lot to think about in terms of the review process, making sure it's done right. avoiding those pitfalls and finding the right person to do this comp equity work. And I want to talk a little bit now about compliance tips, and then we'll finish up with two important notes or challenges that come up all the time, as well as some overall notes to close out. So on this slide, you see some compliance tips, and they come from just doing this a lot and seeing a lot of things that can be done better on the front end to comply with the law on a going forward basis. So one thing out of the gate is, out of the factors that are considered when making pay decisions, figuring out which are tracked in a centralized fashion. So it's often the case that you have things like educational attainment as a factor that determines pay at the front end, but there may not be a system in place that tracks and records that information and then measures it over time to ensure that it's being used consistently as intended. Invariably, when I talk to employers, they'll say, oh yeah, sure, these factors are really important, like conscientiousness is a really important factor when we're looking to hire people, or their professional appearance, where it's relevant, or other factors that are directly related to the job. And they do factor in, but there may not be sufficient memorialization of how those factored in. So the question is, do decision makers keep records at your organization justifying their exercise of discretion? And that can be a double-edged sword, because some people think, well, no, I don't want to have any record kept of discretion being exercised, because what if the discretion is exercised in a problematic way? I think the right path here, given what we see in the law, is to use comp equity review as an opportunity to shore up and guide and offer guidance on how that discretion is exercised, and then have checklists or other ways of memorializing how that discretion is exercised. So you can guide people in their exercise of discretion. So if they tell you conscientiousness is an important factor when hiring someone, memorialize that with a Likert scale, one of those kind of point scales from 0 to 3 or 0 to 5, of how conscientious they appeared based on some evidence. Again, you have to review those factors to ensure that they're not creating a problem because they're in and of themselves they're biased. But that, I think, is a better situation than having a complete empty slate and not have any ability to judge and gauge how much that's affecting the pay decision, if it's important to affect it. And of course, there's other information as well noted here. That's really important to get that shored up. And at least have the strategic conversation within the organization of whether and to what extent those things should be memorialized. More compliance tips. Okay, so we said it's important to avoid, the law says under AB 168, to avoid inquiring about salary history, and there's this whole thing about if it's provided voluntarily, it can be used, etc. My view is, and I should say, some lawyers advise that you should ask about salary expectations, not salary history, as a way to circumnavigate the problems under the law of asking about salary history. My personal view on that is that that's counterproductive to even ask for salary expectations. Why? Well, there's substantial body of research suggesting that women behave differently than men in salary negotiations. And this is research by Linda Babcock and Sarah Lechevre. I note the cover of their book, Women Don't Ask, which is based on empirical data showing that women have a different propensity than men for asking for more in initial salary negotiations and sometimes in ongoing salary negotiations with their employers. If that's the case, and it's also the case that people tend to answer the question about expectations for jobs based on their salary history, whether you ask about salary history or expectations, it just has the effect of kicking the liability can down the road. It could have that effect. And whether you ask about expectations or something else, in the event that you're creating liability down the road, you're still going to be liable for it. It's just going to be down the road. So I think a better way is to not ask those questions entirely and not base compensation on that, and do some of the other things we just talked about finding other criteria and other methods for ensuring when you're hiring that you're doing it in a way that makes sense. Now, I will pause to say recruiters have said, wait a minute, that's not good for us because we need a way to do this in a way that's cost effective and manageable. And we don't want to have situations where we have a mismatch of expectations. Someone comes in thinking they're going to make $200,000 and it's an $80,000 a year job. That's a waste of everyone's time if they go through all the whole process and then an offer's made and it's for $80,000 and they leave, right? That's not good. So I think, and in addition with AB 168's requirement of providing some pay information upon reasonable request, I think it makes sense to my solution is run a comp equity audit or review and then use the information gleaned from that review process, which can give you that information, those ranges, use that information to inform and empower the hiring and recruiting staff to be able to know exactly where the ranges are that won't upset the apple cart, won't create risk when they're doing the hiring. That does require some technical provision of information in a way that's consistent over time, but I think in the end that pays off, and there are solutions like that available. The second question is, how often should you be reviewing comp? How often should you be going through this process? And there are really 4 factors listed here that are really important for answering that question. How tolerant is your company of risk? What is the risk magnitude like? What's the risk profile? Which is really a function of number of employees times the average salary, right? If you have 3 people making minimum wage, it's very different than a staff of people making $500,000, 5,000 people. What's your turnover like? Is it high, medium, low? And what's the frequency of comp updating that happens in your organization? Those are the things that I think matter, and I actually have a worksheet if you're interested of figuring out how frequently you should analyze comp based on those factors. 2 more quick challenges that I've discussed with folks like at the EOC and the DLSE and others that have come up that are worth noting, and they're listed here. One is the issue of inherited or acquired risk. So this happens all the time where an employer will say, well, we have this one block of people in one SSG, but some of them came over, they were acquired as part of an acquisition or some other process where those people came over from another company, and as part of that M&A deal, we had to pay them a certain amount. That unfortunately is not a viable excuse to differentiate or as an explanatory feature, just that they were inherited or acquired. If you have people doing the same work based on the criteria we stated earlier, you can't really rely on that. Now, I think that there may be a time limit there, because if you just acquire them, there may be a de facto excuse, but it's not a de jure one, meaning there is no legal viability for that argument. Now, there may be some kind of practical thing going on there, and it might be something that could be regarded as something that could excuse the underpayment for a small period of time, but I don't know how long that goes. No one does. The second issue or challenge that comes up periodically is this situation of different output not excusing different comp. And here's the example that's used to illustrate that point. Let's say you're talking about folks in the entertainment industry who are indisputably within one SSG at an employer. Let's say they're directors or production assistants. And you have one production that's higher value and one production that's lower value. The difference in the output or the value to the employer of that output is not a viable explanatory feature to differentiate why you're paying the directors or production assistants on one production versus another more, if there's a gender effect. The idea is, think about this as a defense. Would it be a viable defense to say, Your Honor, we have all our male directors working on our high budget pictures, and we put all our female directors on our low budget pictures? Surely that would not be a viable excuse, and therefore, even if you have distributions, if the gap is problematic from a statistical standpoint, net of the other things we just mentioned, all the other things we just mentioned, that would not be, that the difference in output would not be a viable explanatory feature. This is also true in other industries. The hospitality industry, I've heard examples there that agencies have used, or in the tech industry where you have, like, let's say a video game producer and there's a higher value video game and a lower value video game. If you have engineers or technicians and they're all doing the same thing, some are working on the higher value output, some on the lower value output, again, it's not a viable excuse or explanation. Okay, a couple more points that are really important to wrap up. Care must be taken in identification of the roles. Employers should adopt a plaintiff's perspective or an employee's perspective, not just a company's perspective. Ask how a jury or a fact finder might regard the substantial similarity of work based on skill, effort, and accountability, not based on job title alone or the convenience that an employer already has in its pre-existing org structure. It might be the case that that pre-existing convenience is great, but it's not outcome determinative. It could be good, could be great, and sometimes it is, but it's not by definition, axiomatically, the way on which you need to do your comp equity, not the platform. Secondly, be sure to analyze the right compensation. Again, the Act uses the phrase wage rate, but it is unlikely that a California court would permit employers to avoid liability by labeling parts of pay something other than wages or wage rate. And then lastly, and this is a really important point to make, gender equity laws are not anti-discrimination laws. Auditing or reviewing for pay equity compliance is not a review for state and federal gender discrimination laws. And I'll give you an illustration I'll give you an example to illustrate this point. Let's say you had a workplace that just had two strata. You had executives and you had janitorial staff. And all the executives got paid $100,000 a year, and all the janitors got paid $40,000 or $50,000 a year. Let's say you had only men, or you had a sign that said, we're only hiring men to be the executives, and you're only hiring women to be the janitorial custodial staff. And so there's a clear pay differential, right? There's 100 grand versus 50 grand. That would almost definitely be a problem under discrimination laws, right? Because you're hiring men into the higher paying jobs and only women into the lower paying jobs. That's a problem under discrimination laws, but it's not a problem under compensation equity laws. So under the California Fair Pay Act, that would not be a problem. Why? Because no one would allege that you would draw a circle around both strata for purposes of substantially similar work. Obviously, if that were the case, if you want to draw that circle that broad, okay, but I don't think anyone would ever try to say that if the people who are at the highest level and the lowest level, that they should be lumped together based on skill, effort, and accountability. As long as they're doing different things based on skill, effort, accountability, that would not be a violation under the California Fair Pay Act. But it would be under discrimination laws. So it's really important to distinguish those two things. There is no element of intent as part of the Fair Pay Act. Whether you're the best intended employer or the worst intended employer, the same rules apply in terms of the statistical analysis of the math of the differences in the pay. And I can't stress this enough, but if you have one-off claims, this is why this is important. If you have one-off claims where one employee is saying, compare me to that person, you can't do that the same way you may be able to do in a discrimination claim. You can't do that in a Fair Pay Act claim. You have to look at the substantially similar group of employees that claimant is in and look at the distribution of men and the distribution of women and use that as a basis of comparing and noting whether this person is in an SSG where the distribution of women is underpaid relative to men or not. You can't just take one person and compare it to one other man or one woman to one man, because that's the whole point of distributions. You may have some women who are paid less than some women who are paid less than some men who are paid less than some other men, and some men who are paid less than some women. Net of that, it could be the case that some women are underpaid, some men are overpaid, but if you just focused on one-to-one comparisons without doing the math right, you could literally just get sued on an infinite loop where you just do one-to-one comparisons, you fix that, and then you another one-to-one comparison, you fix that. And having talked with agency directors at all levels and plaintiffs' counsel, that cannot be the intention of the law, nor and even remotely close to a correct interpretation of the law. That's why you've got to do it in this correct way, as we described, where it's a distributional analysis and then you're using the correct math to identify explanatory features. That's all I have. Thank you so much for your time. I really appreciate you guys listening and watching this. It's a really important issue. I'm passionate about this issue. As you may be able to tell, I get very excited because I feel like there is a correct and right way to do this. And I hope employers who are watching and listening and counsel who are watching and listening will really try their hardest to make sure they're doing it the right way. I'm always happy to help. Thank you so much.